Margaret Cahir, I'd also like to welcome the publication of this bill exactly 4 years since the general election. I think this one is one of the most complex bills to come before the House in that time, some 172 sections, and it has implications and consequences for several substantial high-profile acts of the Oireachtas, including the Guardianship of Infants Act of 1964, the Succession Act of 1965, the Family Law Maintenance of Spouses and Children's Act of 1976, the Status of Children Act of 1987, the Adoption Act of 2010, and the Civil Partnership and Certain Rights and Obligations of Cohabitants Acts, also of 2010. And obviously the question can be asked why these acts were so high profile and significant, and that is because it impacted so much directly on the lives of hundreds of thousands of individuals and families in this state. And this bill will join the catalogue of landmark legislation passed. I'm also, as others, proud that the Fine Gael Minister for Justice, Minister Fitzgerald, is pursuing this bill, and also to congratulate her predecessor, Alan Chatter, in introducing and leading the bill, or in the initial stages of the bill as well. And I think it's important that, although sometimes disputed, Fine Gael is a party of the progressive centre. We believe in equality and fairness and upholding the law and in vindicating rights, and this bill seeks to emulate all of those aims. In examining the bill, and as I said, 172 sections, we must remember the very recent past and the institutional state-sanctioned inequality and unfairness that existed in our country. We've had numerous reports over the last period of time and numerous apologies, and rightly so, in relation to what has gone on in our past. We must remember, particularly those of my age and younger, that the ridiculous arcane concept of illegitimacy was only abolished with the 1987 Status of Children Act, and prior to this act, those children born of parents who were not married were legally illegitimate. And just in case they or others weren't aware of this, the state issued a different colour birth certificate to remind them. To me, looking back, it seems absolutely ridiculous, completely crazy that such a situation existed, but it did, and unfortunately it exists today in a different way. There are children and de facto parents who do not enjoy the same rights or protections of the law, and this is wrong. And just as the Status of Children Act moved to address these shortcomings and failings, so too will the Children and Family Relationships Bill. The bill modernises the law, and it in effect represents the law catching up with the reality of everyday life in this country. Above all else, the bill is child-centred and addresses a range of areas, including the parentage rights and responsibility, guardianship, custody and access, donor-assisted reproduction, and indeed maintenance. And the bill represents a culmination of a long process of research, reform and consultation. As part of the pre-legislative scrutiny process, this process introduced by this government, the Oireachtas hearings on health and children held important hearings last April and produced a report on the proposed bill. The Minister published the general scheme of the bill last September, and again facilitated further consultation and comment on the bill's contents and its aims. Opponents of this legislation are seeking to link the legislation to the marriage equality referendum, which is equally important but separate. And opponents of this legislation are also seeking to confuse by focusing on families headed by same-sex couples. I've been dismayed, as other deputies have, by the narrow focus some media outlets are also putting on this bill. While it is true that some of the families which will be positively impacted are families headed by persons who happen to be gay or lesbian, the bill impacts positively on hundreds of thousands of families also. And these families include married parents, unmarried parents, grandparents or other relatives who are in a parenting role. With regard to a number of the sections that I in particular like to talk about, Section 40, which enables a wider range of unmarried fathers to become guardians of their child automatically. A father who has lived with the child's mother for 12 consecutive months, including at least 3 months for the mother and child following the child's birth, will automatically become a guardian. And also enable a parent or a parent's spouse or civil partner or a parent's cohabitant of not less than 3 years' duration to apply to the court to become a guardian where he or she has cohabited or co-parented the child for 2 years. And obviously these are in the day-to-day issues that are in the best interest of the child. Section 45, which includes a new section, 6C, putting a new section into the 1964 Guardianship Act, is also welcome and shows that this bill is child-centred. Again, it enables a guardian enables a guardian and parent to appoint a temporary guardian for his or her child through court-based process where the parent is suffering from serious illness or injury and prevent him or her from exercising his or her guardianship responsibilities. Section 51 amends the Section 11B of the 1964 Act will enable grandparents and other relatives to have more easy access more easily to children in the context of relationship breakdown. They will be able to apply directly to the court for access rather than having to go through the present two-stage process whereby they have to apply to the court for leave to make the application for access. So I certainly welcome that. Section 56, which amends the Section 18A of the 1964 Act, will ensure that a child in question can make his or her views known in proceedings relating to guardianship in custody and access cases. And that's where possible, given the child's age and understanding. And also it's welcome that, where the child is of an age that can make their views known, that those views be taken into account and be listened to. I certainly welcome that. Section 66 to 73 of the bill contain amendments to the Family Law Maintenance of Spouses and Children Act 1976. And this again was another landmark act which provided protection to spouses, mainly wives and children, and ensured that other spouses, mainly a husband, could not sell the family home to the detriment of his wife and children, as well as other protections. And the amendment to the bill extends protections in a way that reflects the fact that couples may be of the same gender, so they may not be married or single partnered. Section 75, which deletes subsection 4 of the Status of Children Act, and this means that a child will now be able to make an application to court for declaration of parentage, and is being introduced because it is not in the best interest of a person to know. It is in the best interest of a person to know his or her identity. Section 108 again, and opponents of this section are saying that it confers the right to adopt on same-sex couples. And let's be very clear about it. No legislation, this included, confers a right on anyone at all to adopt. A person has the right to apply to adopt and be rigorously assessed by the adoption authority. And this bill, through Section 108, is extending the right to apply to adopt to cohabitating couples, same-sex or different-sex couples. And this bill is duly recognising that a person's parenting ability is not connected in any way to their sexual orientation. Rather, it is about stability and the ability to provide a safe environment for their child. Overall, I welcome this bill. It's reflective of modern Irish life. It recognises that a child has a right and a need for security and stability, has the right to know that someone has the legal duty to look after them. And it modernises Irish law, encompassing a wide area of parentage, custody, maintenance, adoption, and I certainly very much welcome the inclusion, and hope that it has passage through the Dáil as quickly as possible.